This is Ms. Sherrilyn Ifill. Ms. Sherrilyn Ifill is the President and Director Counsel of the NAACP Legal Defense and Educational Fund. She received her JD from New York University School of Law and her BA from Vassar College. Ms. Ifill, you may begin.
Good morning. My name is Sherrilyn Ifill. I'm the President and Director Counsel of the NAACP Legal Defense Fund, the nation's oldest civil rights legal organization formed in 1940 by Thurgood Marshall. I want to thank Chairman Nadler, Ranking Member Jordan. I want to salute the leadership of Representative Bass and the Congressional Black Caucus on this issue. And I want to extend, on behalf of the Legal Defense Fund, my deepest condolences to the Flyod family and thank them for their courage and their voice at this important moment. We welcome the Justice in Policing Act as a first step in addressing the decades-long call and demand for policing reform. The legislation includes reforms that LDF's policing reform campaign has advocated for years to ensure greater accountability for police officers who engage in misconduct and brutality. Members of Congress incorporated a number of our proposals in the act, which is a step in the right direction toward ensuring police accountability nationwide. I want to first focus this committee's attention on the significance of this moment and the importance of the federal government's role in addressing this crisis. You are in a civil rights moment. In 1964, 1965, 66, and 67, cities all over the North in this country were gripped by urban unrest. In Watts and Detroit, Harlem, Minneapolis, and scores of other cities, Black people took to the streets to protest police brutality. It was during that period of unrest that Dr. Martin Luther King said, "Riots are the language of the unheard." The 1968 Kerner Commission was created to study the source of that unrest. And much of the report's findings and recommendations focused on law enforcement presence and conduct in Black communities. This period overlapped with the years that most people think of as the core civil rights movement, when Black people in the South petitioned, protested, marched, and demanded federal legislation to address segregation, voter suppression, and economic injustice. The result were core civil rights statutes, the Civil Rights Act of 1964, the Voting Rights Act of 1965, and the Fair Housing Act of 1968. But despite the unrest in northern cities, in over 100 cities during that decade, there was no legislation to address the issue of police brutality in African-American communities. And as a result, very little has changed since that period as it relates to this issue. Therefore, too many officers know that they can commit the most heinous acts against African-Americans without fear of accountability. Ranking Member Jordan said that the killers of George Floyd will face justice. But we also know that those who killed Philando Castile, Eric Garner, Terrence Crutcher, Eleanor Bumpurs, Michael Stewart, Clifford Glover, Sean Bell, Amadou Diallo, and countless others never were held accountable for the crimes they committed. That snapshot of former Officer Derek Chauvin kneeling on the neck of George Floyd with his hands in his pockets, looking out with no fear of being videotaped, should shame every member of this body, every judge, every lawyer, everyone who has participated in the perpetuation of a system that calls itself a justice system, but routinely allows officers of the state to take innocent life with impunity. You have the chance now to change that. One of the key parts of the system of impunity has been qualified immunity, a defense that shields officials from the unforeseeable consequences of their act, but has been interpreted by courts so expansively that it now provides near immunity for police officers who engage in unconstitutional acts of violence. LDF has litigated a number of these cases. For example, in 2018, we filed a petition in the United States Supreme Court appealing a decision of the United States Court of Appeals for the 11th Circuit that affirmed summary judgment in favor of a law enforcement officer who tased our client, Carrie Illich, 19 times to death. The U.S. Supreme Court denied the petition, and this case was not a one-off. Every year, cert petitions are filed in the court seeking review of cases in which law enforcement officers have successfully eluded accountability for the most violent forms of brutality by raising the qualified immunity defense. The Justice in Policing Act seeks to address qualified immunity by amending the civil rights statute used most in police excessive use of force cases, 42 U.S.C. Section 1983, and we welcome this amendment. We want it to apply to all civil suits that are pending or filed after enactment of the act, and we'll continue to work towards the elimination of qualified immunity. There's bipartisan support for ending qualified immunity, and so I'll close my remarks by quoting from a federal circuit court judge in a decision issued just this week in the Fourth Circuit Court of Appeals. It was written by a judge appointed first to the bench by George W. Bush. And he said, in Jones versus City of Martinsburg, Judge Henry Floyd said, Wayne Jones was killed just 1 year before the Ferguson, Missouri shooting of Michael Brown would once again draw national scrutiny to police shootings of Black people in the United States. 7 years later, we're asked to decide whether it was clearly established that 5 officers could not shoot a man 22 times as he lay motionless on the ground. Before the ink dried on this opinion, the FBI opened an investigation into the death of yet another Black man at the hands of police, this time George Floyd in Minneapolis. This has to stop. To award qualified immunity at the summary judgment stage in this case would signal absolute immunity for fear-based use of force, which we cannot accept. This decision represents a minority of cases, and so we need Congress to act. You are required by history to meet this civil rights moment. It is a moment in which we have a chance to transform our approach to public safety, to recognize that most community conflicts do not require the intervention of an armed officer, and to speak our values through federal and state budgets that prioritize our commitment to anti-discrimination, to public health, and to true public safety for all. Thank you.
Thank you. Our next witness